Hello and welcome to Rights and Recourse, a program that educates you about your rights and recourse to those violated. My name is Dumila Matez. As we wrap up 2014, we bring you some of the programs that stood out in Rights and Recourse during the year. One of those programs is an old age customary marriage called ukutwala.
The practice of ukutwala is an old custom. It literally means to carry. This is how some of the girls and women come to be married, by being forcibly abducted into their marital home. Bride kidnapping has recently come under the spotlight in South Africa, yet the practice is common throughout the world. In South Africa, it is still rife amongst the Mpondo in the Eastern Cape. But of late, this practice has come under fire for its apparent conflict with women's and human rights.
They told me I was to get married. I said no, I didn't want to get married. They told me that I wasn't the first girl to go through ukutwala, and they forced me to go with them, and they took me away. I cried the whole night. I cried so much.
And while some of the girls have escaped, others, like this girl, remain and have resigned themselves to their fate.
Joining us on the line are Chief Patikile Olomisa, past president of Contralesa and member of parliament, and Prince Mpumalanga Gwadiso from Ngeleni. Just explain to us, how does this custom ukutwala, how was it practiced in the past?
Well, the custom of ukutwala is one of the ways that by which marriage arrangements are initiated. What would happen, there are elements that need to be met before you can conclude that the people involved were practicing ukutwala. It's either the girl was in agreement with the prospective bridegroom that they are to marry, but because they want to circumvent the long and circuitous and involved process of negotiating that agreement, which would involve the parents of the two individuals, they would agree that the man would pretend that he was forcibly taking her into marriage without her consent, so that when that happened, the girl would act surprised, and then she would be taken by apparent force to the bridegroom's home. Then emissaries would be immediately sent to the home of the girl to inform them that the girl, they should not be looking for her because she has been twalaed by such and such a family. And then they would immediately offer a certain number of cattle as part of their offer for lobolo. Then if the parents agree, then negotiations would take place between the two families. If they do not agree, then it means then that attempt to marry has been aborted, because marriage in our culture involves the two individuals and the two families. If the consent of one section is not available, then that marriage attempt has to be aborted.
Gwadiso, is that how you understand the custom?
It is. It is how we understand it.
But what brings this cruelty then around this custom really?
I must also add to what Chief Olomisa has said, that also there is also what is called the ukutwala, meaning that even though they are trying to circumvent the negotiation processes, their agreement is that the girl would just be taken by the man to his home, and having agreed that she is being taken for marriage. And then they would send the emissaries to the girl's home to report that the girl has been taken for marriage. And then the negotiations would follow them.
Minister, isn't that explanation, what's wrong with that explanation of how the custom works?
I just want to add that both Xabecaca and also Xabethwalwa usually also the other concern is that probably the bridegroom is not ready with lobola. So that would be an agreement between two adults, not children, who were in love, who were in agreement that they are prepared to spend their lives together. But because of the long negotiations or the fact that the would-be husband is not ready with lobola, they decide that they do this ukutwala or elope bacace.
Now, let me come to...
But what is important is that it didn't involve little children, 14 years old, 12 years old, and so on.
I just want to say that our position from the promotion and protection of cultural, religious, and linguistic rights of communities is that we work within the Constitution, but secondly, we work within a context. And the present context is that we look at it in terms of the Bill of Rights. And so looking at it in terms of the Bill of Rights, we have to look also, there are so many more acts that have come about that try to protect not just the girl child, but just women in general. Even go so far as to say that when you have actually, even in terms of the Children's Act, outlawed even punishment in schools, that could be extended further, and would go so far as to say it's definitely these days a no-no, for the simple reason that that child is a human being fully fledged with a dignity that has to be protected, with a choice that has to be respected. We also have to be careful in terms of the old patriarchal views that we can act upon women or act upon children.
Why are we charged, was Vumeleni Jezile charged with rape and assault and kidnapping?
Of importance, Butumila, is that we don't have ukutwala as a classified or defined criminal offense that is prosecutable. Hence, we explore two legal frameworks, that is the Sexual Offences Amendment Act, as well as the Prevention and Combating in Trafficking of Persons Act, which is why Mr. Jezile was charged. And of importance, the fact that critical to submissions made by the minister, by Chief Olomisa, as well as Chief Prince Kwadis, was that there has to be the element of consent, which in the case of Mr. Jezile was absent. One, the girl is forcefully removed from her place of residence to the Western Cape against her will. That's kidnapping. Her liberty is deprived, which therefore means it's a criminal offense of kidnapping. Secondly, the girl is 14 years. You know for a fact that from a legal point of view, once you have sex with a girl below the age of 16, that's statutory rape. If she's 12, it's clean rape. And then there's the issue of trafficking in persons. Now, one who forcefully takes a girl child away from her parental home to another place or to his or her custody without the consent of that girl, in fact, the issue of consent is not even at play here. You are actually trafficking that person for sexual exploitation, because there's nothing that you're going to do except to enslave her as your sexual partner. And for financial gain, because then there's the element that does not come to the picture, which many people on Facebook, when I raised this case, were actually critical of the system, to say, what about the parents that when the girl ran away from that man, they forced her to go back to the Western Cape? Now, aren't they complicit to sexual exploitation because they collude, they aid, they assist the perpetrator in sexual exploiting the girl, in enslaving her against her will, when from a cultural practice point of view, the consent element is lacking. And even from a legal point of view, the consent is not recognized, which is the genesis of why Mr. Jezile had to be prosecuted. And it is a precedent that has been set because the NPA, the Justice Department, the law enforcement, Sonke Gender Justice organizations and other NGOs are aggressively adopting a stance that says this is enough. At the end of the day, we've got so many legislative frameworks that we have not utilized in the past because from a legal point of view, we had challenges, but 2 legislations have been legislated in Parliament and now there are answers to our prayers.
Mr. Botha, you could come in. You could
Well,
come in.
I was going to say that, firstly, we should commend this judgment when Dumile, because what has been happening is that people have used and abused, the culture. People have done things that were outrageous in the name of culture. And I'm not here to throw the baby with the bathwater, but there are definitely cultural practices, that all of us, even as Africans, that we must decry, we must denounce. We must also say that they deprive us, and girls in particular, they deprive them of their fundamental right to dignity, to honor. And then I think from Sonke, we in fact were saying that, why is it that, our controllers, House of Traditional Leaders, why is it that their voices are in fact very silent? That's why then it would be important for them to come out clear and say, we support what the Justice Department has done, but also to say, let us, these cases, and they know who continues to twala abantwana. So it's important for them to come and say, we will help, we will name and shame that things should not be done in the name of culture. Especially men who are there, don't do these things also in our name as men.
I want to go back to something you raised during the break we had around counseling this little girl.
Well, that's very important. What is it that we have done? I think it's important, the social development. You have also a minister who's very committed to this, Minister Batabile. It's to in fact ask the question, has the young girl received counseling? Her needs, they've been attended to. Because what we tend to do more often than not is only to focus, and rightly so, and correctly so, on Jezile and what has happened. But the aftermath as to what this girl, the long-term effect of what has happened to her is going to be, it's important for us to say, social development come to the party. But you also, off the air, raised a very important question. What do we do moving forward? That's when the issue of the one-man can, the issue of involving men, young boys, in issues of, rights, in issues of toxic patriarchal tendencies or practices.
Minister, you mentioned earlier there's a lot of work that's being done in the OR Tambo district municipality level. They have a school that they have there, the Palmerton Institution, which actually belongs to the Methodist Church, if I'm not mistaken. And they've asked for help to run that school for the kids who come back from these kind of situations.
Yes, a lot of work has been done. I said over the past 5 years, you could see in the videos there, the former Minister for Women, Children, People with Disabilities, and also the former Mayor of OR Tambo, who have been champions and initiated the awareness-raising programs, education. They even retrieved work that has been done to educate the children. They also worked very closely with traditional leaders. Myself and Minister Batabile Dlamini, we have been in Lusikisiki on a number of times, again to do educational work, awareness raising. I also know that the Department of Social Development in the Eastern Cape, MEC Pemima Jodina, has been in the area with me on a number of occasions addressing the issue of abuse of these girls. The Department of Social Development is supporting the victims through their victim empowerment program, including girls that have been salvaged from such unlawful marriages.
For now, let's take our first commercial break, and when we return, we look at more stories that have made this year a memorable.
Our new waterproof smartphone takes superior photos even in low light. Has PlayStation 4 remote play and up to 2 days battery life. Don't settle for good. Demand great. The new Sony Xperia Z3 series. Our new waterproof smartphone takes superior photos even in low light. Has PlayStation 4 remote play and up to 2 days battery life. Don't settle for good. Demand great. The new Sony Xperia Z3 series.
Get the new Sony Xperia Z3 Compact on a My MTN Choice 100 contract for only $399 and get a free 12-month music streaming subscription.
Because of cancer, I realized life is short. I want to live my dream.
They can burn my face, but not my voice.
I'm definitely not a cross-dresser. South Africa, I'm just a gay man.
Join Puleng Molebatsi on Bupilong every Saturday at 17:30 CAT.
Welcome back. Still on customary marriages, but this time we highlight the pitfalls of not registering your marriage with Home Affairs.
It's a brand new day, and so it's a new chapter in the life of Zandi Lembata. This is a day of celebration for the community of Eshowe. In the Zulu custom, a wedding is a public event. No formal invitations, the news are spread by word of mouth.
Ngibona sengathi lubalulekile ukwenza izinto ezifana nalezi ikakhulukazi kubantu abasebasha njengathi nalabo abancane abasuke bengakafinyeleli eindaweni zokuthi nabo baze bafinyelele ukutheni bashada ukuthi babone ukuthi mase beshada ngakusasa usiko lwabo indlela kukhomba nendlela ukuthi kufanele sibheke ngaphi.
Mongeni Biela is only 26 years old, but already expected to be the next chief in the Biela clan. And the journey to his homestead in Nkandla is the final long-awaited stage of a long process as preparations begin way in advance.
Kothekuseni bese beyodlala isangweni. Udlala abakubo kamakoti abakubo umkhwenyana. Umakoti usehlezi ngaphandle nonina nabo bonke zinsizwa namantombazana abadlala lapha esangweni. Baqede lapho bese bahambe besihlahleni.
Like the Western tradition, the groom is not allowed to see the bride before their union is formalized. The cattle play a very important role in bringing the couple together, starting from ilobola to the bride leaving her household to her new life.
Amantombazana asiphula ishoba. Ebese yawulinika umakoti endlini, mawubulala inkomo, inkomo ibingafi.
On the other hand, this ornate box, while bearing a whole lot of gifts for the in-laws, also carries with it an even deeper significance.
Yabona leli yabhokisi lifana noma iba uyemoshal. Ukhiphe isitumbu emoshal, sifake ebhokisini, usithathe, usise emangcwabeni. Akuthi manje uphelile lo muntu ekhaya, usisuwe emangcwabeni, uyongcwatshwa. Leli bhokisi njobe yogana uyathathwa lapha leli bhokisi uza nalo lapha useyobizwa ngesibongo salapha lapha eyoshada khona Ufana nomuntu ofileyo manje kubo. Uthathwe naleli bhokisi walethwa la. Imabe xabana behlukana nendoda yakhe. Ngeke alithathe leli bhokisi. Yolishiya lapha ekhaya. Leli bhokisi ngoba kwaphuma inkomo ziyomthenga kweza leli bhokisi.
The jovial competition between the two sides lasts throughout the whole day, building up to the highlight of the event. After a local induna has led the couple in their vows, men appointed from both sides of the family will give praise to the ancestors as everyone remains quiet in respect for the ritual. The wedding ceremony ends with the bride giving gifts in the form of blankets to her new family, including the extended family.
Gentlemen, there was a truly traditional or customary marriage taking place in that insert. Is that what we know about customary marriages?
Well, I would say it's part of the celebration of the customary marriage. It's one of the processes that are required in terms of concluding the customary marriage. Then that's one of those processes.
Mr. Malakate, we have a liberal constitution. And why did we have to go back and recognize customary marriages when we have a liberal constitution? Or does the constitution allow for us to recognize customary marriages?
It does. We had to go back because simply the constitution was just to put in a framework of how the government or how the country should be run. But then you have these other pieces of legislation that have to conform to the constitution. Hence, we needed to go back and recognize marriages that are entered into and concluded following customary customs. That's the best answer that one would give in that situation.
With all the negative connotation that the customary marriages have, where the wife is subordinate to the male partner.
Well, look, with the advent of the Constitution and the Recognition of Customary Marriages Act, we've gone a long way from moving away from those practices. For instance, in terms of the Recognition of Customary Marriages Act, now a female spouse in a customary marriage has equal status and capacity as the husband, which means she can sue, she can be sued in her own capacity. We need to remember that any law that we have in this country needs to be in line with the Constitution.
Initially, customary law was not recognized by the old laws that we had under apartheid. And only now with this constitution are they recognized. Why were they not recognized?
It was to a certain extent recognized in terms of the Marriage Act of 1961, but with limitations. However, with the new dispensation and looking back at the apartheid system and to rectify what happened previously, the new act was introduced to be in line with the Constitution. Because if you look at Section 39, subsection 2 of the Constitution, it's quite clear that for each and every law that you need to interpret, you have to look at the Bill of Rights. And recognition of Customary Marriages Act was also introduced to also protect the basic rights of indigenous people.
The law does allow or recognize polygamous marriages for as long as there are certain processes that are followed.
Closing remarks, Mr. Mabaso?
What's important for people to know is that if the Department of Home Affairs refuses to recognize and register their customary marriages, they can always approach the courts and satisfy the court that all the requirements were complied with, and the court will give an order directing the Department of Home Affairs to recognize and register the marriage.
Mr. Nameng?
I think generally people need to approach legal aids. I know information is not forthcoming to a lot of people. And like I said earlier, when you don't know your rights, it's like you don't have rights at all. People should be encouraged, and I think the Department of Home Affairs must try to find a way of how to give information to the people so that then this act serves a purpose.
I hope that has given you renewed thoughts on how you can strengthen your legal recognition in your customary marriage. We will take a short break, and when we come back, we'll be up close with the Chief Justice.
Our new waterproof smartphone takes superior photos even in low light. Has PlayStation 4 remote play and up to 2 days battery life. Don't settle for good, demand great. The new Sony Xperia Z3 series.
Zoom into Africa. This is Burundi. The president is Mr. Pierre Nkurunziza. Burundi got independent from Belgium on 1st July in 1962. The population is more than 8 million people. One of Burundi's major languages spoken is French. Monetary unit is Burundi franc.
Technology is all around us and is improving lives across Africa, like how young Nigerians are connecting to the internet. There are doctors finding new ways to save lives in Cameroon, and the South African public transport system that is now getting Wi-Fi. We have gadgets, apps and loads more, some of which play a big role in Africa's growth. A huge part of this African growth is technological innovation. To find out a bit more about social media and technology news from here in Africa and abroad, join me, Siphumelele Zondi, every Sunday at 7:30 p.m. on SABC News.
It's not every day that you get to sit down and have a discussion with a judge, let alone a Chief Justice. But Rights and Recourse in 2014 had an exclusive interview with the Chief Justice of the Republic of South Africa, Justice Mogoeng Mogoeng.
The Constitutional Court was established in 1994 following South Africa's first democratic elections. The court is representative of South Africa's diverse population and untainted by the past that was established to protect, interpret and enforce the Constitution. The Constitution is the supreme law of the land. It contains a Bill of Rights that enshrines the fundamental human rights of all people in the country. The Constitution also divides the powers and functions of government between the legislature, the executive and the judiciary, and between the local, provincial and national spheres of government. No other law may conflict with it, and all organs of state are bound by it and are obliged to respect, protect, promote and fulfill the rights it enshrines. The Constitutional Court is the highest court in the country.
Justice Masale.
The court hears appeals, directs applications, confirmation proceedings, where a lower court has declared legislation invalid, and may review bills of parliament.
No way can the story of our hectic past and its historical transition to democracy be told other than being at the Constitutional Hill. Many of our political icons such as Nelson Mandela and Mahatma Gandhi were once detained here. What was once a place of injustice and brutality has now been transformed to a place of solidarity and democracy. We are delighted to have Chief Justice Mogoeng Mogoeng with our presenter Dumile Mateza in the studio, and let us hear what he has to say about this historical heritage site.
Thank you, Bali. Chief Justice, good afternoon and welcome to Rights and Recourse.
Good afternoon, Mr. Mateza, and good afternoon to your viewers too.
And probably for the benefit of those who do not know, who is Justice Mogoeng Mogoeng?
A man from very humble beginnings, in a village called Kofikral, somewhere in the Northwest Province, the Platinum Province, who grew up under very difficult circumstances, with very little resources available to even dream of completing matric. We're very grateful that South Africa is a land of many opportunities. Here I am, having gone through university, having practiced law, having been a judge. This is my 17th year as a judge, by the way. So that's just about who I am, passionate about ensuring that the injustices that our people have suffered over the centuries are put to rest now that I have the opportunity to make a difference.
What are the objectives of the norms and standards issued by the Office of the Chief Justice?
The objective was to make sure that the courts, the functioning of the courts is facilitated through the norms and standards. You are able to inject a measure of efficiency and effectiveness in the court system because, as you know, the public has been complaining over the years about the inordinate delays in the court system, cases that sometimes takes up to 6 and even more years to be finalized, sometimes in circumstances where all the evidence you need, all the witnesses you need are available, the many postponements that have been taking place, judgments that are reserved and people have to wait for rather too long before judgment could be delivered. You needed a mechanism in terms of which a vision geared at ensuring that there is efficiency and effectiveness in the court system and that cases are, all things considered, finalized expeditiously without compromising the quality of justice becomes a reality in our system. But also to introduce a case management system that would facilitate all this.
In the presentation you made on the promotion of democracy and constitutional justice, you're quoted as saying, the central features of a constitutional democracy, the right to life, the right to equality, the freedom of religion, the freedom of assembly, universal suffrage, the right to dignity, freedom of expression, which extend to the media and other outlets. How can these be preserved through the Constitution?
Well, you would recall that all these are to be found in the Bill of Rights, and that's Chapter 2 of our Constitution. It is therefore the responsibility of the courts and all those who are given the power by the Constitution to give practical expression to these constitutional responsibilities, these constitutional rights, to ensure that these rights are enjoyed, and for the courts, when disputes are submitted to them for adjudication, to ensure that the outcome is in line with that which would give expression to the rights of the people. So the Chapter 9 institutions as well, they've got a responsibility to make sure that these rights are given practical expression to. So is Parliament, by the way, and the executive.
Are these norms universally accepted by the judiciary?
Well, on the 13th of February 2014, after we had given all the courts in this country the opportunity to express their views on the norms and standards, the heads of the superior courts met and overwhelmingly adopted the norms and standards. And the next day, the 14th of February 2014, I had a meeting with the leadership of the national leadership of the magistracy, and they unanimously adopted the norms and standards. And the 28th of February, which was last week Friday, they were gazetted. So they are operational as we speak now. But like any other thing, you will always have dissenting voices. In fact, I'm not aware of anything in particular that humanity is agreed on that it is the right thing to do. Some believe water is good, others think something else is much better than water.
There are people in some circles in the legal fraternity who claim some anxiety for political manipulation of the Judicial Services Commission. Is that what you perceive the JSC to be?
No. In fact, you'll find that people will never tell you about how America appoints judges. In America, unlike in South Africa, you don't have any judge involved in the process of appointing judges. It is only politicians And I haven't heard any of the critics of the Judicial Service Commission referring to America, which is probably the world's oldest democracy. Some of these oldest democracies, judges are not involved. Ours is a much more transparent system, which is even opened up to the media. You know, I ask colleagues, and I won't mention the jurisdiction, where there is no politician involved in their judicial appointment process. The media is not allowed there. And even when you want to know why you were not appointed, you are not allowed to have access to the information. So I think, just to wrap it up, I haven't experienced any political manipulation. We get involved in very robust deliberations, and at the end of the day, when we have understood each other, a decision is taken. No political interference.
Mr. Chief Justice, thank you very much for your time. After the break, the story that captured the imagination of the world. Don't go away. Stay with us.
Molweni, nda, dumelang, assalamualaikum, namaste, goeiemorgen, Jumbo Africa, and a very warm welcome to AM News here on SABC News Channel 404. The Basic Education Minister, Angie Motshekga, has dismissed the renewed Limpopo textbook saga as a storm in a teacup.
They have to collect books the previous year. And it's actually the very principles, if that's what they told me was true, they'll be ill-disciplined because they were supposed to have collected books so that state doesn't buy books because you don't buy the same books every year. A book is supposed to last for 3 years. So they are supposed to collect them so they don't run short.
That's AM News, daily at 10 a.m. on SABC News.
A tragic story that led to the downfall of a global sporting personality at a prime of his career. Probably let me start all with this question. I understand, reading the Act, reading the Criminal Procedure Act, is that a person who is charged in a Schedule 6 offence, it normally does not get bail, but in this case of Oscar Pistorius did get bail. Does somebody want to venture an answer there? Why?
I think I can try and answer your question, Dumile. We must remember that the presumption of innocence is fundamental to our Constitution. Section 35 of the Constitution, everyone has a right to be presumed innocent. Now, when considerations are made around the granting of bail to an accused person, relevant circumstances or circumstances which are taken into account are whether or not this person will stand the trial, whether they will disturb the public peace, etc., etc. So this is what a court, when tasked with that, has to take into account. Now, Section 60, bracket 11 of the Criminal Procedure Act then imposes a duty on the National Directorate of Public Prosecutions to, in instances where it is a Schedule 6 offense, your premeditated murder, your rape, murder of police officers, etc., etc., to then issue that certificate to court saying we are going to charge this person in terms of Schedule 6, the sixth schedule to the Criminal Procedure Act.
I also read somewhere, but that note was never issued.
Yes, it wasn't, and therefore Magistrate Desmond Nair did not err in that instance because this person is innocent. We must remember that, yes, the objective facts are that River Steenkamp was killed, but at that stage, at the pre-trial stage, it is very, very important to take into consideration the fact that the trial still needs to continue.
Immediately when something like this occurs, is that many people believe, because of the stature of the person, that he's going to get preferential treatment. Mr. Minister, you probably want to talk about that, preferential treatment or non-professional treatment? All equal before the law.
Yes, certainly our Constitution is clear
that all indeed are equal before the law. But before I respond to that, let me indicate that Schedule 6 is one of various measures that over time were introduced to tighten our law, our criminal law, in response to popular demand that our criminal justice system is perceived to be soft on crime. For example, we introduced minimum sentences with regard to certain serious offenses, which initially attracted a bit of a resistance on the part of the judiciary because they felt that sentencing is their prerogative. But I'm raising this because one of our policy thrusts in the current administration is going to be to evaluate the criminal justice system overall, to see where are the weaknesses, but more importantly, to bring it closer to the people, to make sure that people feel that the justice system is responsive to their aspirations, their idea of what the justice system should do to counter the surge of criminality that currently prevails in our country. But in relation to the issue of equality before the law, certainly that is the principle. Judges are expected not to bow or to succumb to popular views when dealing with a specific offense or a specific case. And certainly you would agree that in this instance, people may have views about the judgment itself and the sentence, but the judge showed that she, despite public perception and popular views, she could maintain what she was convinced to be the right decision. Me and you may have our own views about how correct she was in the application of be it dolus or culpa, but that's another matter. Obviously, appealing the decision would have academic consequence on our side, unlike with the prosecution, because it will just be to clarify the questions of law without, if I understand correctly the way it works, reversing the sentence that's been imposed. So for me, what is more critical, which is an ongoing exercise that we do, is to constantly evaluate the law to see how effective is our law, how responsive is it to addressing the scourge of crime. Whether at sentencing, as you would recall I mentioned the minimum sentencing legislation, or at tightening the crimes themselves so that we start criminalizing more behavior. To illustrate, for example.
Let me get final comments from you, and in your final comments, Brenda, and you can talk about restorative justice, Mike, and Brenda, I just want Brenda to touch on the correctional services facilities around the country, how good they are and how they will look after Mr. Pistorius.
Well, I think Mr. Zach Modise set the record straight. It's not all perfect, but at least our correctional centers have changed from what they used to be, and the Correctional Services Act changes the whole thing around in that they are not even regarded as prisoners, but people who have offended, who need to go out and become active members of society once rehabilitated.
Michael?
Excuse me.
Oh, excuse me. You have a frog in your throat.
I do. I think the general point that I'd like to make in conclusion is that as part of this general evaluation and assessment of how well is our system working, I'm absolutely convinced that we overuse punishment way too much. And we expect far too much from it. So it leads to a serious overcrowding, as I'm sure the Minister would agree. But we expect it to denounce behavior, we expect it to deter behavior, we expect it to change behavior. And internationally, it doesn't do any of those things. Internationally, it's actually a completely inadequate tool. So I think that we need to look much deeper and see how else can we accomplish these aims.
Mr. Minister? Sorry, Michael.
No, I think I need to put a few facts in perspective here. Our correctional facilities, as we speak, have the capacity to take 120,000 inmates. We're currently at 155, which is the surplus constitute the overcrowding phenomenon. It varies from correctional facility to correctional facility. Now, 41,000 of those are in remand custody. Now, remand simply means that there is pending trial or an ongoing trial. Now, there is where the gains, efficiency gains, can be achieved.
When we come back, we'll take a look at another sporting life that has been shortened prematurely.
We kick off this week's show by seeing how Kenyans are paying tribute to the victims, as well as not only how they've coped, but how they returned stronger after the attacks.
Last year, images of the 4-day Westgate Mall attack saturated front pages.
In the Democratic Republic of Congo, artists have assembled to celebrate the peace this war-torn country has not had in a long time.
No conflict that can't be solved without a conversation.
The Journal, every Saturday at 1:30 on SABC News.
Welcome back. At the end of October, another tragic story hit South African sporting fans. This time, Orlando Pirates and Bafana Bafana goalkeeper and captain Senzo Meyiwa was shot and killed at his girlfriend's home in Vosloorus. While many of his fans around the world were celebrating the arrest of the suspect, this was, however, short-lived.
Sounds of horror. Sounds ordinary South Africans seem to have become all accustomed to. And here, in the townships, children play around seemingly oblivious to the danger, whether at home or at school. While South Africa's crime levels have been worrying year after year, it is the most recent incidents of violent crime that have grabbed the attention of everyone, here at home and abroad. Frustrated with the daring attitude of criminals, communities have blamed the country's justice system and law enforcement agencies for doing little. Recent incidents got even the country's top cops involved, and citizens think it is because this time criminals hit on high-profile individuals. First, it was the shooting of Member of Parliament Jackson Mthembu in an attempted robbery. This incident saw senior officials scrambling to assure citizens that they will track down the perpetrators. And in no time, the suspects were arrested. Then, it was last week's fatal shooting of Orlando Pirates and Bafana Bafana goalkeeper Senzo Meyiwa. And this incident drew local and international attention. Even the country's police commissioner, together with her senior police officials, rolled up their sleeves, all vowing to leave no stone unturned in bringing the suspect to book. This attention left ordinary South Africans asking why these recent attacks on prominent individuals receive a response. People are still asking why criminal incidents involving ordinary people did not receive this urgent attention. Meyiwa's death has even resulted in renewed calls for stricter gun laws. But these are not the only incidents citizens are appalled about. The rape and murder of 3 toddlers rocked the entire nation. And only days ago, when the suspect was eventually sentenced to multiple life terms, did the nation have closure with that shocking death. But South Africans are still trying to come to terms with another child killing. 4-year-old Tigran Morris was killed after being dragged on the side of his mother's vehicle during a car hijacking incident in Regepak a couple of months ago. This week, police arrested the boy's suspected killer.
Our constitution states very clearly that all citizens are equal before the law. If so, why then are there different strokes for different folks?
Well, that's in a nutshell what we are about here today. But first of all, Lieutenant General Makgale and Mr. Guy Lamb down in Cape Town, I must first congratulate the police for having apprehended those who committed the heinous crime of killing Senzo Mahiwa and Tegan Morris.
Thank you very much. Our police officers out there are continuing to work very hard on all the cases that have been reported. We are very grateful for the support, the overwhelming support, I must say, that we've received from members of the public. We continue to receive phone calls. As a result, we were able to question about 13 people in relation to the killing of Senzo. So we are very grateful for the support.
The question being asked in that insert, it said the Constitution says all of us are equal before the law. The question being asked is why all of a sudden you've arrested this man so quickly and it took you 3 months to find somebody with regard to Tegan Morris?
Well, investigations differ. You know, if something happens right here, right now, and there are witnesses and the suspect is still on the scene, we're able to effect arrest immediately. Some of the cases you have to investigate, you must do identity parades, you must get your informer networks out there, we must mobilize the community to come out and support in terms of providing information. So it all differs. Sometimes it takes longer than 6 months or a year to find the suspects.
Not all poor people and most poor people are not violent criminals. I think it's the conditions which one needs to look at. Most violent crime committed in this country is committed by young men under the age of 40. It's usually between the ages of about 16, 17 and upwards. And it's about focusing on those particular men and the particular environments in which they live. So it's around, we know that many come from poorer communities where there aren't opportunities available to them, where there aren't jobs, where essentially around didn't get the best possible schooling, may have experienced violence within their particular life. Because we know of what studies exist on violent perpetrators, most actually encountered violence within their childhoods, which contributed to them being much greater risk of committing violence. But it's around, you know, we still don't know exactly, I mean, the reasons here are really, really broad and really, really complex, but it does effectively come down to gross inequality, lack of employment opportunities, and the fact that, you know, there is sort of this pervasive culture around using violence as a means to solve problems.
That is a view from an analyst, but what is the experience of the police?
Well, we share the same view that policing in this country is not going to be solved by the SAPS alone. We need the communities to come on board. We need other government departments to come on board. We need the churches and other civil society organizations, because the root causes are exactly as have been explained. If you go to Eastern Cape areas in, you know, Port Elizabeth, the same in the Western Cape, particularly where you've got gang violence, you find that the social conditions there are terrible, and the young people that we arrest, you know, 16, 18, 20, 25, like the one that was involved in the murder of Senzo, it's people that are unemployed. It's people that, some of them, or majority of them, they're probably using drugs. So it's a difficult situation, I believe, for the country. The police are out there doing their best, but I think we need other role players as well on board. They are there, but, you know, we can always do with more assistance from other government departments and the community.
The South African Football Association has made a proposal that we should charter the Senzo Mahiwa gun law, and that gun law must take all the unlicensed and illegal firearms off the streets. And we must take those guns to the furnace and build a statue for Senzo Mahiwa.
Any law that does not achieve its intended objectives, that law, at any given rate, it must be a matter or subject of review. We think that the Gun Control Fire Act, given all what it is now, our experience on the ground, The reality and the law do not talk to each other. We make a call particularly to the justice system. We think that courts must show no mercy to people who are found guilty, convicted of murder, manslaughter. And courts must not consider personal circumstances of anybody, regardless of circumstances.
South Africa has fairly rigorous and fairly detailed firearm control law. The key issue here is, and I think the spokesperson for the ANC, Zizi Kodwa, did point out, was it's around understanding the implementation. Is the problem sitting within the courts? And I think what we may want to think about here is to do a comprehensive review. To give you an example, at the time JFK was assassinated in the US, President JFK, there was a response to set up a high-level commission to look into the nature of gun violence within the US, and led to kind of a series of recommendations.
Unfortunately,
and it was a comprehensive assessment.
Guy, quickly, unfortunately, we have run out of time. Let's get the view quickly from Lieutenant General Makale.
Well, we concur. The minister indicated that there's going to be a review, and I'm sure all of us will be supporting that review to make sure that we have the kind of legislation that is going to support us.
Well, it's been a riveting discussion here around the issues that we're dealing with here in South Africa, gun laws and violence, brazen violence around South Africa, and you have heard your views. This debate is long from over. This has been Rights and Recourse. Now we've come to the end of our program, and thank you to all our loyal viewers throughout the year. And wherever you are, enjoy the festive season, and please don't drink and drive. From all of us here at Rights and Recourse, from me, Dumila Mateza, and the rest of the team, we'll see you next year.